This program is brought to you by the Practicing Law Institute, a nonprofit learning organization dedicated to keeping attorneys, professionals, and accountants at the forefront of knowledge and expertise.
Hello and welcome to the inSecurities podcast, keeping it fresh and staying wonky on the latest securities, regulatory, and enforcement developments with a practitioner's perspective on the stories you should be following. As always, I'm Chris Ekimoff, and I'm here with my co-host, Kurt Wolf.
It is good to be with you again, Chris. It's hard to believe, but it's December already. I know you've had your Christmas tree up for quite a while, but did you at least take a moment to enjoy Thanksgiving with friends and family?
We did. Longtime listeners will know that Kurt often ribs me and my wife about the fact that when Halloween is over, the Christmas tree goes up. We have had a great month of decorating and are really looking forward to the holiday season here. And definitely paused for some turkey and football last week. How about for you?
Yeah, absolutely. I spent Thanksgiving in sunny Florida for a change this year. It was an interesting place for me to spend Thanksgiving. I'm used to cooler weather maybe, like a pickup football game on Thanksgiving morning. Didn't get any of that this year, but a good Thanksgiving nonetheless. Of course, one of my favorite things that I got to do over Thanksgiving this year was pick through the SEC's annual enforcement results for the fiscal year 2024. The SEC dropped that on us on Friday, right before Thanksgiving on November 22nd, which was a little bit later than we've seen the report come out in recent years. I will say it's been drifting. If you think back maybe 10 years, it tended to come in like the third week of November, the last week of November. And then there was this period of time where they would send it first week of November, last week of October. We're sort of drifting back toward the end of November, which means we all have plenty of time to read it over Thanksgiving. Now, in fairness, a few weeks ago at the Securities Enforcement Forum in Washington, D.C., Sanjay Wadhwa, who is the acting director of enforcement, put us on notice that the results were going to come out a little bit later in November. So I don't think anyone was surprised or disappointed. Now that I've seen it, I can say that, again, this year, the SEC opted not to do the sort of glossy 20, 30-page report that they've done in some years in the past. It was a more simple press release, which has been the habit over the last couple of years. It still runs about 12 pages if you print it out. So, I mean, a little more detail, I think, than we've seen in the last couple of years, and certainly plenty to unpack. Which is exactly what we're going to do on the podcast today. And we have the perfect guest to help us do that. We are very lucky to be joined by the person who was running the Division of Enforcement until very recently, Gurbir Grewal. Now, I know that Gurbir is a household name for our listeners, but a little bit of background is always helpful, I think, before we get into it. So for those of you who are not familiar with Mr. Grewal, he is now a partner in the New York office of Milbank and a member of the firm's litigation and arbitration group. Before joining Milbank a few weeks ago, of course, Gurbir served as director of the SEC's Division of Enforcement. During his tenure, the commission brought over 2,400 enforcement actions, resulting in orders for more than $20 billion, with a B, $20 billion in financial remedies. These matters included more than 100 enforcement actions addressing non-compliance in the crypto space. I think we've talked about that before here on the show. A series of high-profile enforcement matters protecting investors in private funds from market manipulation and misleading or inadequate disclosures regarding conflicts of interest, fees, and valuations. The first trial finding a defendant liable for insider trading in the shares of a peer company, which is a nice way of talking about shadow trading, another thing we've talked a bunch about here on the podcast, and a number of other significant matters that you've read about that we've been talking about for years. Before he was the director of enforcement, Gurbir served for more than 3 years as Attorney General of the state of New Jersey. He also served as the Bergen County prosecutor, which is the chief law enforcement officer for New Jersey's most populous county. And he was an AUSA for 10 years in the Eastern District of New York. and then in the District of New Jersey, which included stints as chief and deputy chief of the District of New Jersey's Economic Crimes Unit. So maybe more about Gurbir than our listeners knew before, but as I say, I think it's always helpful to get to know our guest. Anyway, without further ado, Gurbir, thank you so much for joining us on inSecurities.
Well, thanks, Kurt and Chris. It's a pleasure to be here. And the only thing I will say is that had I still been in charge, the report would have come out sooner. And so that's all on Sanjay. And, again, if I was there, you would have had it early November, late October at the latest.
I'm guessing, though, that we wouldn't have gotten to talk to you about it. So on some level, I'm very happy that things have worked out the way they did.
There you go.
And I guess just as a brief aside, Gurbir, I mean, you obviously have spoken many times over the years. How does it feel to not start today's conversation with a disclaimer?
I feel so liberated. I mean, I've done a couple of panels recently, and to be able to go in there, obviously I'm still bound by ethical rules and confidentiality, but to be able to speak a little bit more freely and candidly and be a little bit retrospective and critical, candidly, it's a good feeling. So, I hope to have a nice open conversation with you within ethical limits and confidentiality restrictions. But I do feel great about being liberated.
That's a great way to kind of kick off what we want to get into. Kurt referenced the SEC enforcement annual results. Again, came out on November 22nd. And just to hit on some of those top line figures that always get the headlines, that always are covered in the press releases and the client alerts. In fiscal 24, the division filed 583 total enforcement actions and obtained orders for a total of $8.2 billion in financial remedies. That $8.2 billion is the highest amount in the history of the SEC's enforcement program in a given year. The press release from the SEC.gov website announcing the results went on to flag a few key themes for this year's enforcement activity, including, among other things, crediting market participants for what they term as proactive compliance, as well as proactive initiatives addressing widespread non-compliance relating to off-channel communications and the marketing rule, as well as robust financial remedies and cases involving emerging technologies and emerging risks. Gurbir, you talked about speaking openly, maybe even critically today. What are some of the things that you would take from the annual results that were announced on the 22nd?
Sure. And I'm sure we'll dig into the numbers and the penalty figures as we go through our conversation. But I think at a top level, I think the results are consistent in hitting on the themes that I talked about when I first started in the role. When I started in 2021, I made clear that our goal was to restore public trust in our institutions, in our financial markets, in regulators. And I said the way we were going to do that is by focusing on being proactive in our enforcement efforts, by being proactive in the remedies that we sought, and by trying to create a culture of proactive compliance with gatekeepers, with registrants, because we can't do it alone. To me, those are the three pillars for an effective enforcement program. And I think if you look at these results, in all three of those areas, the commission and the staff and enforcement delivered. When I talk about proactive enforcement, it's making sure we're using tools like sweeps and initiatives to stay ahead of emerging risks, to make sure that we're affecting compliance in our markets, to make sure that we're having registrants and others play within the chalk line, so to speak. When I talk about proactive enforcement, it's moving our cases more quickly so we could then look at emerging risk areas. And for example, in this year's report, we talk about the AI washing cases that we brought, because that's an area where there's going to be a tremendous amount of activity, regardless of who's in enforcement in the future. I think that's an emerging risk area where we need to stay on top of. And I think the results here show that the staff was being proactive in its enforcement efforts. When I talked about proactive remedies, it was seeking financial penalties that actually had a deterrent effect, that promoted compliance, seeking remedies that kept bad actors out of the markets. And you see that being delivered on in these results as well, with the numbers with respect to bars and the like, and obviously the disgorgement numbers and the penalty numbers. And then a point of emphasis for me, certainly in my last year, was to make clear that none of this is about just ratcheting up and moving in one direction. We tried to do within the framework that we have whatever we could to put out there what it means to cooperate, what good corporate citizenship looks like, what good compliance looks like, what proactive compliance looks like. And I think more so than any other period in the commission, in recent commission history, we had more no penalty settlements, more $0 settlements. We had more detail in commission orders talking about the behaviors that resulted in cooperation credit. Maybe it's not enough. Maybe there's more that we could do there. Maybe there's more of a framework to build out there for the next group of folks who lead the division for the next chair. But I think we got it going in a direction where we're giving lawyers like me now the ammunition they need to go talk to a client to say, hey, here are the benefits of going in. Here's what you could expect to get as far as reduced penalties or cooperation credit. So I think in each of those areas, you saw a very effective program. You saw one that delivered on the three key areas that I had identified as priorities in year one. And I think you saw a concerted effort to really restore that trust in our institutions and our regulators and in our markets through the work of the incredible staff at the division.
Yeah, I think that's fair. And I especially like the point about how I think the SEC has tried, or the division has tried, to say more about the types of conduct or activities that are likely to result in some kind of cooperation credit or maybe more favorable settlement terms. I noticed in particular with some of the sweeps or the cases that were part of sweeps that were announced at the end of the year. We're going to talk more about sweeps in a few minutes. But if you kind of look from one order to the next and scroll down to that section where they talk about the things that the companies, the firms did to cooperate with the SEC, or the remedial measures or other steps that they took, there is more detail than I think what we've seen in recent years in those orders. And when you can sort of compare them side by side, which is easy to do when you get, 11 or 24 in a day, I think it's helpful. People have to be willing to do the work to go in and read those things. But you're right, Gurbir. I think there is more out there now for folks to digest in that space.
And I think there's more to be done, right? I think one of the things that I wish we could have accomplished during my time was find a way to make public the declinations. I know the folks who are on the other side of those declinations don't necessarily want their information out there, but in an anonymized way or in a summary way that, hey, we looked at this particular violation, we looked at this type of entity, and here's what they did, here's how they came in, and here's why we did not make a recommendation to the commission. That's sort of unfinished work that I think would have really aided practitioners and market participants.
Well, I'll tell you, and then we're gonna move on to the numbers. But on that point, I agree, and I think both clients and the defense bar would love to know more about those declinations and the circumstances in which the staff will agree not to bring a case. The lowest hanging fruit, or at least the way I've always thought about it, is if you sort of within a given year look across disclosures that are made in folks' Qs or Ks. Sometimes companies will disclose publicly that they are the subject of an SEC enforcement investigation. And there's always a materiality analysis that happens before they get there, right? But it does happen with some frequency. And in the instances where the SEC declines to bring a case against a public company that has disclosed publicly that they're under investigation, that seems to me like the kind of thing that should be fair game if what you were trying to do is paint a picture of the types of cases that are likely to result in declination. So maybe, not for you to do anymore, but maybe the next person who is in your chair on a permanent basis can start there.
Well, I hope the next director of the Division of Enforcement is an avid listener of our podcast, Kurt, because we are giving them a very long list of things to consider and do in the coming term.
It's possible that they've been a guest, but we'll have to wait and see how this shakes out. Anyway, all right, look, we do have to talk about the numbers. That's right. I know no director or former director ever really wants to talk about the numbers, but they were fascinating this year. Mm-hmm. Both good, and I won't say, well, maybe I will say bad, but we'll leave that up to you, Gurbir. So as you mentioned earlier, Chris, the SEC announced that it filed 500 enforcement actions in fiscal year 2024. I won't sugarcoat it. This is a historically low figure. The division hasn't seen a number in the 500s since before the financial crisis. In fact, as far back as I could go, finding where the numbers are still available on the internet, I can't find a number in the 500s, and that's like back to 2008. So we're kind of low. And I guess, Gurbir, I would ask, what should we make of that? Do you have any thoughts on why it was lower than what we've seen in recent years?
I do. And before I give you the reasons why it was lower, I think it's important just to talk about numbers in general. You started off the podcast by talking about how we moved away from a glossy report to a press release. That was intentional on my part. I don't think we need to be in an environment where we measure the success or lack of success of an enforcement program by the number of enforcement recommendations that are made. We should not be in an environment where we measure the success or lack of success of a staff attorney by the number of cases that they bring, because you don't capture the cases that they've investigated, that they've worked on, that they've had a Wells meeting with you or some other member of the bar where somebody makes a compelling case and the staff or the division director or the deputy say, you know what, that's a different way of looking at what went on here. And we're going to decide to move on from this and we'll, close this case out. So, during my career, I've had the privilege to lead a number of enforcement programs. And I said this during my time as a federal prosecutor, as a county prosecutor, as a state AG, and even as enforcement director. We don't measure our success by the number of actions or convictions, but by whether we did the right thing in each and every case. And I truly believe that. It's true in the regulatory space, but it's especially true in the criminal space. It's about doing the right thing and doing justice in each and every one of these cases. And we want the staff to exercise their discretion to close those matters, like I talked about, when the facts and law don't support the recommendation. There shouldn't be pressure to bring cases, period. So I sought to de-emphasize the year-end numbers. We moved away from the glossary reports. I went out of my way internally to recognize with directors' awards those members of the staff that investigated something that didn't result in an enforcement recommendation. And even those cases let registrants, market participants, the public know that we're the cop on the beat out there. And so if I'm looking at numbers, Kurt and Chris, to measure efficiency and effectiveness of a program, I'm looking at the number of matters that each unit or office has. I'm looking, when I was director, at the number of matters and the complexity of matters that each staff attorney is carrying. I'm looking at how quickly those matters are moving from opening to closing or from opening to the recommendation stage. I'm looking to see if the matters we didn't bring, for example, referred to state regulators or to other regulators. I'm looking at our litigation docket. I'm looking at the number of our emergency applications. All of those numbers, to me, tell the complete story of the program. So that's sort of the bigger picture answer on how I view numbers, and always viewed numbers as a public servant leading a number of different organizations. But to answer the question about why the numbers were where they were, I think there are a number of reasons, but first and foremost among them have to be the Supreme Court's decisions in Jarkissi, have to be Cochran, have to be the concerted attack on agency power and the use of the administrative form by regulators like the SEC. I believe Jarkissi came down in June of this year.
Yeah.
And as a lot of SEC practitioners who listen to this podcast know, we basically needed to hit pause. And we did that. We hit pause to assess the impact of Jarkissi on number one, matters that had been resolved. Number two, pending matters where there was a settled recommendation to be presented to the commission. And number three, matters that were in the pipeline, right? That was a lot to take stock of. And I think it's fair to say it took us several months between June, July, and even creeping into August. And the result was, in some cases, the dismissal of a number of APs. The result was revisiting a lot of settled recommendations, obtaining waivers from respondents who were settling in the administrative form, doing side letters and agreements on how to resolve that. The result was shifting those cases we would have brought in the AP setting to district court. And you saw a lot of that. And so I think nevertheless, we pushed through those headwinds. And what you've seen this past October and November are probably the busiest Octobers and Novembers in recent memory or history, right? And so I think if we want to see how the last fiscal year was, you should look at October and November as well, because those are the 2 months or more that we lost as a result of Jarkissi. But now that's a boon for whoever comes in next. They'll start off with a cushion of 2 months that are busier than most Octobers and Novembers. And that's how arbitrary these numbers are. And so that's just, the most, that's one of the explanations. There are others. I do think there was a lot of foot dragging on people's parts to see if the regulatory environment would change in the leadership at the commission based on what was going to happen in the election. Certainly a contributing factor, but largely it was jarcossy.
I'm glad, Gurbir, that you've taken the time to kind of explain, I think, something that everybody inherently would agree with, right? One number is not the way to judge the success of the division or the commission generally. But let's talk about a second number that has been, pretty eye-popping and touting here. That's the $8.2 billion in financial remedies. We can all acknowledge is the largest amount in SEC history. Now, of course, with all of the qualifications you just described, there's a couple of others too. $600 million of that is from those off-channel communications cases we talked about. There's a couple of others that are in the 9-digit range, 100 million for those cases as well. But even if you take those out, right, those kind of big outliers, we still have a significant increase in those financial remedies. Now, we're looking at more dollars with less actions. That's, for every accountant out there, right? That's something to talk about. I'd love to hear. That's right. I'm sure, right? That's what you think. Well, how do you think about, kind of that interplay and how you viewed penalties across your career leading the Division of Enforcement? I remember you've given multiple statements on the importance of penalties, not only as a remedy, but also as a message to the market. So here we are with $8.2 billion on less actions. What are your thoughts?
I think the one thing you could take away from the penalty figures across the 3 fiscal years plus that I was there is that we did try to recalibrate penalties, and penalties for the same violations during earlier commissions would have been lower. And we did move up because we did want them to be meaningful and to have a deterrent effect. And I think you saw that most acutely with the off-channel communications penalties. The very first resolution was for $125 million with us. And if you look at the prior history of those resolutions, they were nowhere near that neighborhood. But I think a lot of that was driven by the fact that when we were meeting with these registrants and they would come in and make very compelling presentations, it wasn't really about that the misconduct was excusable in any way, but that the penalties should be more in line with these historical numbers. Hey, Gurbir, if you look at the last 10 years of these types of cases, the highest penalty has been only X. And it would be unreasonable for you to move beyond X. And to me, and maybe it was me being new to the commission, maybe it was me having a different background than most people who come into this role. When I looked at that, I said, well, you're showing me 10 years of ineffective penalties if the conduct has been continuing across registrants for all this time. So maybe we need to ratchet it up. And so for that reason, I think the penalties, whether you're using the statutory tiers or how you're counting them, need to be, in the realm of 100 million or whatever the case may be. And so there was a deliberate ratcheting up to affect deterrence in particular spaces. So I think that is something that cuts across the 3 fiscal years, that full fiscal years that I was there. But like the other numbers that I talked about, the monetary numbers are always skewed by large settlements or resolutions. And candidly, some of those resolutions, when I walked in the door in FY21, may have originated in different fiscal years. It could have been an FCPA matter that was filed 3 years before any of us even walked in the door, and it was resolved, in fiscal year 2022, right? So I don't think they always, for the same reasons, tell a complete story. But if there's one through line, I think it's that we were trying to be more intentional in the penalties we were seeking in our cases, and that sort of cuts through regardless if it's 8.2 or 6 billion or 5 or 4, because there's a lot of reasons for those numbers. And Terra was a big part of that, the 4 billion plus resolution there.
One thing that I keep coming back to is, Kurt, one of our favorite phrases on this podcast, whenever we're asked about specifics, facts and circumstances. Right, that's always the answer, and to me, Gurbir,
is that a drinking game for you?
For our listeners, hopefully they are not driving and playing that game.
You would not make it very far through SEC Speaks if that was the drinking game. But, yeah.
But to that point, I think it's interesting, and I'd love your take, Gurbir. It seems like the market and the defense bar is constantly leaning on the commission for more examples of things like what is proactive compliance? What is a self-reporting, metric that I can aim for? What is a penalty that I can expect? But they want the answer for what it'll apply to their own case, more so than maybe what it is to the market. And that's just something that rang with me when we talk about facts and circumstances. We take all of these metrics individually and try to pull out some broader thoughts about that. And we then fall back to rely on facts and circumstances from the other side. I don't know, Kurt, if you've got a feeling as a defense attorney as well, where that kind of interplay is between what can be prescriptive from the actions that are brought and the penalties that are provided, and how you just kind of deal with each at bat based on the pitcher that's in and the way that the game's going.
I mean, I think it sort of plays out exactly the way Gurbir described it, right? My job is to go in and try to get the best result, the most fair result for a client, right? So in advocacy mode, I'm probably going to say to him something like, listen, I've done the research. Here are the 5 most recent cases that look like this.
Right.
And here's where I think a penalty ought to fall, if I think one is appropriate at all, or here's why I think the conduct is different. Now, it's difficult as an advocate if the response you get is something like, well, we're taking a different view of penalties and we don't think that range is the right place to land anymore. Mm-hmm. But that's the dialogue, I think, so it's sort of a combination of both of those things, I think, in practice.
Yeah. And don't get me wrong, the prior settlements and precedent should definitely be a starting point for these conversations. Mm-hmm. And I was using that as one example and sort of a string of cases
of course.
Where I didn't think those penalties were working and that the recommendation to the commission should be for a greater penalty. But I do think that's where we should start the conversations. I do think that there's a value to that. And again, this was, now that I'm a little bit more introspective and retrospective, it's really what I was trying to get at towards the end. And I made a speech on cooperation about, the 5 sort of behaviors that reflect good cooperation and should result in cooperation credit. And what that credit should look like. And if you look at that speech, I think more so than any of the other speeches that I've given, we really collected a lot of the cases. And there are robust footnotes in there and string cites for practitioners to go to say, hey, my cooperation, my self-report looked a lot like this. My, violation may be in line with these other off-channel cases, but here's what we did to self-police, and here's why how we identified it. And so I think there's useful conversation starters for that type of dialogue, and it has to be a collaborative process,
of course.
And if you look at that speech, part of it is also directed at the staff, that it has to be that sort of meaningful engagement that you talked about, Kurt, that back and forth in conversation. It just can't be, no, I think it needs to be higher. You lose credibility as a regulator, and I hope the staff is more engaged or has been more engaged in these conversations. Certainly when things came to us and we had those meetings, despite all this, they're not having Wells meetings. I think I had more Wells meetings than my predecessors. And I read everything. I read endnotes, footnotes, and sometimes endnotes and footnotes in the same submission. And, it's something that I really prepared for because it needed to be meaningful. And you're taking the time to present on behalf of your client, and I need to take the time to evaluate your arguments and respond to them and have that meaningful back and forth.
Excellent.
I mean, I think the credibility goes both ways, frankly. Just as an advocate, that's why I do the work, to try to figure out where I think this thing might land. And some of that is really just being able to advise my client of where it's possible that a case could land, right? Saying, I don't know where the staff is going to come down, but this is sort of the range. I can't then come into the staff and say, these cases typically settle between 100 and 120, but, I think it ought to be 0. You lose credibility.
Right.
Quickly. Yeah. So I appreciate the dialogue around settlement figures. And I will just note that I have talked publicly about that speech and said specifically to folks that they need to look at the footnotes. And I've made the joke, the accountants like Chris always say, you need to read the footnotes. And I've said in this speech in particular, the footnotes are where it's at. It's very helpful. So you've got at least one fan out there who read the footnote and appreciated the color.
Excellent. I want to move on, Gurbir, to probably, I'll say, the second largest number in the results, even though, the mathematicians out there will fight with which number is really larger. Maybe the most shocking. According to the annual results, the SEC received 45,130 tips, complaints, and referrals in 2024, the most ever in one year, which includes 24,000 whistleblower tips. So first off, Gurbir, thank you for listening, reading, and reviewing each of those individually. That is a lot of work to cover in a single year. But on a technical aspect, I'd like to kind of talk about the differences between those two numbers. We've got 45,130 at the top end and 24,000 whistleblower tips. Now, an SEC whistleblower submits a form TCR, which I believe stands for tip, complaint, and referral. But here, the report is talking about that kind of differently from whistleblower tips. So if we think about 24,000 whistleblower tips, that leaves us about 21,000 tips, complaints, and referrals. Are we a difference without a distinction there? What are we talking about with those two types of numbers?
So those 45,000, or I forget what the number you quoted, you have it in front of you. That's the number of total TCRs that have come in during the fiscal year. So someone has gone to the website, filled out the form on the website for the TCR. There's a part of that form where the individual or entity or lawyer submitting the TCR has the option to identify themselves as a whistleblower. Are you making this TCR as a whistleblower? And is that the process that you want to now participate in? And so out of that greater number that you mentioned, the 45,000 or so, out of that number, 24,000 folks checked that box and said, yes, consider this a whistleblower tip. And then, you've got to follow through on the whistleblower process. And when there's a notice of covered action, you've got to go through that process as well. But that's the first step, checking that yes box. And that's why you have those two different numbers. Not everybody identifies as a whistleblower.
Understood.
Got it. Well, that sort of makes potentially the follow-up question more interesting, right? So 24,000 of the forms had the little box tick that said, yes, I'm a whistleblower. I want to, put this in the whistleblower path. Of those 24,000, more than 14,000 were submitted by only 2 people. That was a shocking figure. It's unlike anything I've seen in the whistleblowing space, in whatever 12 years now that the program has been around. I mean, what does the SEC do about that? These don't seem like they're likely to be the kind of high quality tips that the SEC hopes to receive. So what do you do with that?
I think what you do is you take steps to identify who those individuals are. And then there are provisions under the whistleblower rules to prevent them from submitting tips in the future or to pursue actions against them. I don't recall what all the potential remedies are, but there's specific provisions if you submit false claims, if you submit, fraudulent claims, or, in the case of a whistleblower, if you've gone through the entire process and you submit 3 or more frivolous, whistleblower applications, there are tools that the division has to prevent those individuals from submitting whistleblower tips in the future and getting relief from a court to bar them from doing so. So I think that's probably going to be the next step. I mean, clearly it seems abusive on its face. And my guess is somebody has really good computer skills and knows how to write code or do something that's going to, flood the system. And that really, to your point about me looking at all of them, obviously I did not look at all 45,000, but we do have people, right? We have an entire office of market intelligence. And the danger here is that if you're sidetracking the staff in that office with, tens of thousands of, again, I don't know the quality of each of these, but let's say frivolous claims, that's preventing them from looking at something that might be a righteous tip that we need to follow up on more quickly. And that could be dangerous to investors. And that's why I would hope that the commission, particularly the division, the Office of Whistleblower, are thinking about ways to get relief here and prevent these folks, if they are truly abusive, from abusing the system.
Just to talk about the numbers quickly, that is each of those individuals filing 19 tips a day, every day, for 365 days a year. And as a reminder, the co-hosts of the inSecurities podcast also do have a full-time job. We are not the 2 individuals who have been submitting 19 tips a day every day for a full year.
Certainly not. But that does leave, 10,000 or so tips that are more likely, I think, to be high quality. And we know from past experience that the program has been and continues to be a useful tool for the SEC, for the Division of Enforcement, to identify potential misconduct that warrants investigation.
I think some of our highest quality tips are obviously from whistleblowers. And when you are somebody out there counseling a client on whether to self-report or not, the risk you run is that somebody blows a whistle on you and comes in and provides that information. And while the numbers around the payouts over the last number of years have been huge, they're driven off the recoveries in those cases, which have likewise been large. And so I think that success of the program is building on itself and attracting more high quality tips. And folks need to be cognizant of that as they consider whether or not to self-report.
Yeah, agreed. Another tool at the disposal of the division is sweeps and initiatives, which you mentioned earlier. It's something that you've talked about several times when you were the director of the Division of Enforcement. And if we look back at 2022, you gave a speech where you explained, quote, "Another way that we work to address the declining trust in the financial markets is by conducting proactive enforcement sweeps and initiatives that specifically target recurring issues. Filing multiple coordinated actions simultaneously not only demonstrates accountability, but also has a more pronounced deterrent effect than if the commission filed separate standalone cases at different times. You can expect to see us employ these strategies more frequently moving forward," end quote. Indeed, we have seen that quite a lot in fiscal year 2024. By my math, cases resulting from sweeps were about a third of all of the actions brought in the fiscal year. I guess I would just love to hear a little bit more about how you think about sweeps and how the SEC can use them effectively to root out potential misconduct.
So, as I said in that speech, I do think when used properly, they could be an effective tool. And when I look at the off-channel communication sweep, I've been a regulator at the federal level, at the state level, at the local level. I've engaged in sweeps and initiatives in all those roles. I have never seen a sweep or initiative change behaviors in a positive way like I have with the off-channel communication sweep. And what I mean by that is, I remember going to SIFMA for the first time, and that was after we brought our first set of cases here, and I saw panels on off-channel communications and what registrants should be doing around their requirements here. I saw vendors selling solutions in the exhibit hall, right? And I saw that sort of continue. And so I think the sweep at inception and through, early stages was having that desired effect. Now, this is, the introspective version of me and sort of the retrospective version of me. And as I look at sort of the arc of these cases, I think my advice to whoever the next enforcement director is would be continue to use initiatives and sweeps because, like I mentioned in that speech, by the very nature of these sweeps, they're attention grabbing and it's much more effective than bringing cases in a serial fashion. But as you're sitting there with your teams coming up with sweeps in particular risk areas, you need to also at that same time figure out what your exit strategy is going to be. What's the off-ramp here? What does success look like in this sweep or initiative? At what point do we transition this to examinations? At what point have we made the message clear as to what the requirements are and what the consequences are? At what point do we bring in FINRA or other regulators to handle these types of issues if it touches on their jurisdiction? I think those conversations need to happen when you're drafting out and architecting, if that's a word, architecting or designing, these sort of initiatives. I do think they're effective. I do think that there has to be consideration on the front end of what the end goal is and what the exit strategy is. And I think at some point we wanted to ensure fairness that if you are, entity number one and you resolved on day 1 or 2 or 3, and you're entity number, 30, and you were part of that same initial batch of requests and you dragged it out for 6 months or a year, is it fair to stop at this point and let you off the hook if you're a similarly sized registrant and you drag your feet? And those are the types of things you need to think about on the front end. And I think those fairness considerations, I think in some cases maybe it went on too long before the referrals to FINRA and exams were contemplated. I thought it was winding down. I think Sanjay sort of said I was part right at Securities Enforcement Forum in DC. I don't remember his exact words, but I think that's sort of my view on sweeps, sort of looking back, and I'm happy to dig in and unpack any of that.
I mean, I think it leads us to some of the things we've talked about today as we're kind of talking about this elephant in the room, right? Who is next at the Division of Enforcement? Gurbir, you've been so impactful in the years that you served as the director. What are some of the things that you think that you enacted that came to pass in your tenure that'll remain with the next administration, whomever it might be?
Oh, that's a hard question. I mean, I could tell you what's going to change.
That's the next question. We'll get there next.
Again, I do hope, as we just talked about, that sweeps and initiatives are used. I do hope that a lot of the things that the public doesn't see about internal processes and improvements that we made stay in place. And some of that was really giving the staff the support they need to do their cases efficiently and effectively. And, the public doesn't know this, but, we had a 24-hour rule. Like if you were in one of the regions or units and you had a pressing question and it was collected by our front office counsel, we would get back to you, unless it was super complicated, within 24 hours to give you the guidance you needed, the input you needed to move things in your cases. So we were never the cause of delay, that we were a pump, not like a filter on these things. And we were making sure folks had the tools they needed to do their jobs effectively. Like there's things out of the spotlight that I hope improved things for the staff and are not changed. I think the work that we have done that doesn't get a lot of the attention, we stood up these affinity fraud working groups in pretty much each of the regions. That's super important to me because I've seen, both as a local prosecutor, as a state attorney general, how fearful some communities are to come report crimes when they've been victimized, particularly in these affinity frauds around ethnic communities, religious communities, minority communities. Maybe they don't have status around immigration issues and they're afraid to come speak up, but they're victimized, And so we made a concerted effort to do outreach with victim communities. Eric Bastillo in Miami, Rockstar, like making networks with the Haitian community. We brought a number of cases there, Ponzi schemes, crypto Ponzi schemes out of our Houston office, targeting particularly vulnerable communities. I hope that type of work continues, that type of effort to go interface with victim communities who might not have been really on the radar. So those are some of the things that I think about that I hope continue.
Great.
You mentioned that you have some guesses about things that might change. So I'll take the bait. What do you think might be different in terms of priorities or process in the next administration?
Yeah, I think priorities and approaches will change. I think certainly we have a little bit more clarity with the names now being talked about as the potential, or the name being talked about as the next chair. I think it's happened while we've gotten ready for this podcast.
Yeah.
That's reassuring to me that someone who has worked at the institution, at the commission, someone who has a respect for the commission and its processes and the people, who's deeply admired there, is potentially the next chair. I don't think people need to fear that whoever comes in is going to say, hey, my enforcement director, go hit print on the list of all the cases, and here's the ones I'm going to kill, and here are the ones that I want to focus on. Like, that's a conversation that's never happened in any of my experiences in taking over any program, and the public should rest assured won't happen. What will change, for sure, is an approach to penalties, particularly with public companies, right? This is where a lot of these debates have happened. Are we harming shareholders, or are we, sending a deterrent message to companies to behave better? Unless we could prove corporate benefit, according to some, we should not be seeking penalties from public companies. These are the types of debates I hope we have moving forward and have had in the past. And I think that's the type of thing that certainly will change. Crypto, absent allegations of fraud, is going to be handled very differently. You may have a commission that is going to offer more off-ramps for those stuck in these litigations. And really, folks are stuck because we brought a number of cases where we alleged, in my mind, clear violations of the securities laws. I don't think we were making it up as we go. I think it was a clear application of established law and rules to the facts here. But the bottom line is there are not any meaningful off-ramps here for settlements. And so perhaps a future commission is going to hit pause and stay some of these cases while there's a legislative fix, or while there's exemptive relief contemplated, or while there's a different approach taken on these matters. So that will definitely change. Cybersecurity matters. We've seen in recent commissioner dissents that there's an element they think of re-victimizing the victims. The flip side of that is we don't want folks who've been the victim of data breaches, certainly public companies, to re-victimize others, investors who are not being provided information about what truly took place. There may be a different approach there. There may be a different approach on using 13b2b and internal accounting controls to bring these sort of cases. Commissioner Peirce has called it a Swiss Army knife, and some have said it's like smashing square pegs through round holes to drive something home or get a resolution around these cases. And the history of these statutes don't really marry up to what we're trying to do here around having, guarding these crown jewel assets that are, in the case of one of the cases, their software product. And so I think you'll see changes there. You'll see changes on the more technical violations, like the off-channel communications cases. There certainly will be, an end and a referral and a wind down, which there's been a long wind down. It probably should have been a shorter wind down, but you'll see exams take over. You'll see FINRA take over. You'll see, different ways. And unless those issues present in other investigations, you won't see similar hammers, drop on those sort of violations. And then for new rules, I think you'll have more engagement, more risk alerts, more interaction with registrants, and maybe that's more time before we enforce against the marketing rule again. I think that's where I see the changes around the edges. But I think the staff will be engaged and continue to stand up for investors. But just the differences are going to be on the edges.
I'm excited to know that this episode, Gurbir, will be required listening for whomever, takes the seat as chair, as well as the director of the Division of Enforcement. We've talked a little bit about looking forward, but I want to spend some time too looking back. You talked about some of the things that were most important to you in developing over the past 3+ fiscal years of your work as the director of the Division of Enforcement. Are there other things that you're particularly proud of now that you've had a whopping, 6-8 weeks to reflect on such a long tenure? What do you look back? Where do you find yourself thinking about your time as the director, and maybe a legacy that you're proud of in the time past?
Listen, I think I'm immensely proud of the staff. I'm proud of the staff in dealing with everything that we dealt with over the last 3+ years. Again, there have probably been challenging regulatory environments in prior decades, but I think the attacks, both from the courts, both from registrants and other sophisticated actors and in the public space, the attacks from Congress and folks on the Hill, I don't think I've seen anything with the tenor with which we were sort of put under a microscope, where our motives were questioned, where we were constantly challenged. And so that's a difficult environment for folks who truly do this work because they want to stand up for others. That's why I've did it for 20 years, because it's not for any degree of glory. It's because you really get a job satisfaction as a local prosecutor standing up for crime victims, as a federal prosecutor standing up for victims, for me as the state AG standing up for the residents of my state, for me as enforcement director standing up for investors. That was the motivation. And so it's really hard for folks who do this work for the right reasons to be constantly under the microscope. So I'm immensely proud of how we dealt with those challenges, how we persevered and continue to stand up for investors. I'm proud of the steps we took to reclaim trust in regulators, to really drive home the message that we are holding folks accountable, that we are being proactive in all these different ways. And maybe if somebody looks at this 5, 10, well, not 5, but it's got to be a little bit of space. 5, they'll still be like cursing me. 10, they might forget about me. In 20 years, whoever's got the podcast after you guys might look back and say, hey, this guy really cared about public trust. And the 3 pillars that he focused on as, what's most important to an effective enforcement program, that's really how we should be viewing this work. And maybe it resonates with somebody, and maybe, they think I did the right thing for the right reasons, because that's what it was always about for me.
Gurbir, thank you so much for taking the time as you transition out of the Division of Enforcement and back into private practice to look back at these results as well as your tenure as the Director of Division of Enforcement. We've loved kind of following your speaking and some of the things that the Division of Enforcement has done over our years, Kurt, almost mirroring exactly the time that the Director had served. So we appreciate you joining our podcast.
It was my pleasure. Thank you so much for having me. It's been a great conversation, and happy holidays to you all, and continue to enjoy your tree during this month. You had it on for several months, I understand.
I'll let my wife know. Thank you.
Yeah.
Thanks for joining us for this episode of the inSecurities podcast, and a special thanks to our guest, Gurbir Grewal of Milbank. We always love to hear from you, our listeners. Look for us on social media to share your thoughts, comments, or topics you'd like us to explore on future episodes of inSecurities. Please use the hashtag inSecuritiesPod on X or LinkedIn to join the conversation. You can find me at EcomoffCPA.
And I'm at Enforce_update.
Don't forget to subscribe, rate, and review inSecurities wherever you listen. Be well, everyone, and we'll see you next time.
Thanks for tuning in.
Thanks for listening to inSecurities, a podcast from PLI, the Practicing Law Institute. PLI is a nonprofit provider of authoritative professional services training and continuing education. In an increasingly complex business environment where intricate corporate structures reign, inSecurities can help you make sense of it all. A special thanks goes to the producer of inSecurities, Daniel Peinitz, as well as hosts Chris Ecomoff and Kurt Wolf. For more information about PLI's SEC Institute, or to view hundreds of hours of fresh and relevant on-demand programming covering changes within the security sector, visit pli.edu/membership and sign up for a privileged membership. These recorded materials are designed for educational purposes only. This podcast does not constitute legal, audit, tax, consulting, business, financial, investment, or other professional advice, and it does not create an attorney-client relationship. Please consult a qualified professional advisor before taking any action based on the information herein. Furthermore, the views and opinions expressed in this podcast are solely those of the individual participants. These views are not the views of the hosts or their employers. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission from PLI.